na lawyer for ikasa wiye no na enka ne mampanyi John Dramani Mahama so lawyer for wo mo na de nsem no kopie mu wo court wo mo so ebegina simpie so enam so ema Dr. Dominic Ayine wono so ebe kasa na o chese ensem a odansini ede court ni na no hwa anya agro bi na omudie wo hwe ensem no mu a enye petesa ensem ne mu odu ena ensem no so mu onyina so eno nti wo ma amma court se wo mo de Ghana fo ba bedi agro anase court no mo ba no abese ne brekeke ne mum wo mo ba na wo mo de nsem no poti se de sitie no aba ba chenti nsem wo mo de ko ne de emu odu pa.
Today was very eventful, and I'm sure when you watch the proceedings you came up with the impression that the John Mahama team brought a solid case to the Supreme Court. In fact, when we filed the petition, it was being bandied about all over the place that our petition was empty, that it had not disclosed a reasonable course of action. Well, today was your answer. I am sure you saw vividly the evidence that was being led by the General Secretary. We have not yet concluded the hearing, and so I will not comment on the merits of what he said. But I'm sure you are all witnesses and you know that this is not an empty case. Now, let me correct one misrepresentation, very deliberate and gross misrepresentation that lawyer Frank Davis, my very good friend, has made this afternoon. He sought to give the impression that we came to court because we wanted a relief to the effect that His Excellency John Dramani Mahama be declared the winner of the election. I am sure, as ladies and gentlemen of the press, you have read our petition. Nowhere have we sought that relief from the court. What we have sought from the court is very simple and may be summarized in two. First, we want the unconstitutional conduct of Jean Mensa to be held to account. Secondly, we want the court to declare that none of the candidates met the threshold requirements of Article 63, Clause 3 of the Constitution. That is the crux of our case. And that is the case that we have sought to make in court today with the witness statement of the General Secretary of our party. Now, it is far from being the case that John Dramani Mahama himself must testify in this matter. He has filed a petition. He is entitled as of right under the law to call witnesses in aid of his case, and that is what he has done. In 2013, His Excellency Nana Addo Dankwa Akufo-Addo never testified. Ladies and gentlemen of the press, if you have evidence that His Excellency Nana Addo Dankwa Akufo-Addo testified, please bring it to us. He did not testify. He called witnesses to testify on his behalf. So is it the case that when it comes to His Excellency John Dramani Mahama, the law must change and compel him to testify? I am surprised that a senior lawyer of Frank Davis' stature is confusing petitioner with witnesses that the petitioner calls.